You'll hear argument next this morning in Case 13-983, Elonis versus United States. Mr. Elwood.
Mr. Chief Justice, and may it please the Court. The First Amendment permits restrictions on the content of speech for a few well-defined and narrowly limited classes of communication, clearly supported by history and tradition, including what this Court has called true threats. But if you look at the tradition, threatening speech was not punishable at common law, and until the late 20th century, American threat statutes required or were interpreted to require proof of a subjective intent to place the listener in fear. And because of that,
that was an assault at common law, wasn't it? If you threaten somebody with violence and don't actually apply violence, it's still an assault, isn't it?
I think assault is somewhat different because assault can also be an attempted battery. But it's my understanding there is law to the question that assault, when it involved placing someone in fear, did require a specific intent.
It is not necessary for the defendant to have the purpose of causing fear, but it's sufficient for the defendant to have knowledge that it will cause fear.
Mr. Elwood, when we look at fighting words statutes, we've never applied this kind of heightened intent. As I understand fighting words prosecutions, that all the government has to show is that you've said something that would cause a reasonable person to punch you in the face. And that's all we ask. So why shouldn't this be basically the same as that?
It's a very different tradition. Fighting words, traditionally, there wasn't an inquiry. There were some cases that required it, but traditionally there wasn't. Whereas in here, it's pretty clear that there was this traditional requirement that the person have to intend to place the person in fear. But here's the reason behind it, which is that, fighting words has been essentially whittled down to a very, very small category of speech because, basically, under the government standard, any sort of speech that uses, forceful language or violent rhetoric could potentially be at risk.
Mr. Dreeben?
Thank you, Mr. Chief Justice, and may it please the Court. This Court has made clear that true threats, which may not be the best term in the world to describe them, but it is getting at an important point, cause fear and disruption. The mens rea component is that the individual has to know and understand what the individual is saying. Congress reasonably presumed that people who are speakers of the English language and who know that the words what the meaning of the words is that they speak are accountable for the consequences of those words. What we want is a standard that holds accountable people for the ordinary, natural meaning of the words that they say in context.
Well, but in context is right. What is it? Is it a reasonable person, and the examples that were given of the teenagers on the Internet, or is it a reasonable teenager on the Internet?
The context that was used under the jury instruction in this case, and I think that it's an appropriate one, it's more protective of the defendant perhaps than a reasonable listener approach, is a reasonable speaker approach. We all know that if we're communicating among friends, particularly in face-to-face context, we can say certain things that will be understood as sarcasm. But when we widen the audience and put a statement out in a situation where reasonable people are going to react to it by saying, this requires attention, this is a threat against an elementary school.
But it doesn't seem to me answers Justice Scalia's hypothetical of the friend who calls to report the threat, or another hypothetical. One student says, I have a bomb in my lunch pail, and the other student hears it and tells the principal. Under your view, the person who hears it and tells the principal could be liable.
No, that's not our view, and I think it's important to clarify.
What is the suggested instruction you would have in order to eliminate liability in my hypothetical, or Justice Scalia's hypothetical was the same thing of the friend?
The statement has to express a serious intention of the speaker to inflict bodily harm on somebody.
That was not in the instruction that was given in this case.
Not literally, and it wasn't requested, and I think that it is implicit in it.
Well, if you're saying it's waived, that's something else. But the instruction given by the district court in this case does not meet the standard you just gave.
Thank you, counsel. The case is submitted.